Hello viewers, you're watching the Doordarshan Kendra Kohima. Welcome to another episode of Talk and Know, where we discuss topics that matters the most. In this episode, I'm joined by two of the top police officers from Nagaland for a very important discussion on the new criminal laws. Joining me on the panel, we have Mr. Limasunab Jamir, IPS. He is the Inspector General of Police Range of Nagaland. We also have Dr. KPA Ilyas, IPS. He is the DIG CID. Thank you very much, gentlemen, for joining me on this panel discussion.
Thank you.
Well, as guardians of law and order, the police force is our frontline heroes who help us maintain peace. They investigate and prevent crimes. Most importantly, they uphold justice, but at most times they are at personal risk. Today in this discussion, our top police officers will help us understand the new laws and how these new laws will have an impact on the police force and the people in general. So kicking off this conversation, I'm straight away coming to you, Mr. Limasunab. If you could, tell us, help us understand the context of how this new laws, the three new laws came about. There could have been an amendment of the old laws that were already in existence for over 160 years, but please help us understand the context.
Thank you very much, Madeline, for having me, and good afternoon to all the viewers. I think we have to see in the context of the three new criminal laws which has come about, the amendments which have come about, in terms of the need for change which has been felt for a long time. As you have rightly mentioned, the British era laws were 160 years old. As far as 160 years old, the Indian Penal Code was framed in 1860, the Evidence Act was framed in 1872, and the CRPC went through various amendments, but then it has the vestiges of the British colonial time. So the changing dynamics in social environment in our nation, in our country, as well as the technological advancements which have been made. This has necessitated, the need for the criminal laws to be amended and to be in tune with the times. And then primarily colonial rules were basically to serve the interests of, mostly the colonial rulers. But in the present context, the criminal justice system, the word justice becomes very important. And here, the focus is not just on the accused, but there's a victim-centric approach. So when we talk of the victim-centric approach, we are talking about the complainant or the victim of the crime. And the new laws envisages, or the new laws has this perspective of looking at the victim as a very important part of the criminal justice system. Secondly, one of the main primary cause has been the delay in criminal justice system. You are aware that the long delays happens in the court. There's a delay in investigation. There's delay in trial proceedings.
Right.
Where justice is justice delayed is justice denied. So with the advent of technology and the maximum use of technology in terms of electronic video, videography, and other electronic means of communication.
Right.
I think integrating this into the criminal justice system, right from the scene of crime up to the trial stage, will really expedite the criminal proceedings. So that will also help in delivering justice, in a very speedy way.
Okay.
So these are some of the changes which has been envisaged, and this is in keeping with tunes of the time. And then the nature of crime is also always evolving,
Right.
always changing. For instance, if you talk of cybercrime, cybercrime was not there maybe 20 years back, but now cybercrime has become such a prominent part of the crime,
Right.
crime scenario. Likewise, organized crimes like interstate crimes or international crimes, all this has to be dealt with as per the law. So all this necessitated the change, and it is reflective of the changing societal dimension and the technological changes that is happening. And this will help transition our country's legal system into the new technological age.
I also want to take your take on that, Dr. Ilyas. Also, if you could help us, Salima has mentioned about the criminal justice system. If you could help us understand this concept.
Criminal justice system is premised on justice, which simply means that giving everyone his or her due. For example, when an offense of theft happens, the due which is for the person who lost the money is to get the money back. The due who have taken the money is kind of reformation for him, and where required a kind of punishment where he undergoes a certain time in jail or maybe community service. by which he gets his due, and the society gets its due by getting the assurance that that kind of an activity will not be encouraged and it will be met with sufficient punishments. So, this is the fulcrum about which the criminal justice system operates, and as Lima sir rightly said, the earlier system, the juristic foundations of the earlier version of the laws did not have that much importance of the crucial element of giving justice to the victim. So, that part has been taken care to a great extent, because the victim is now entitled to get a copy of the FIR, the victim is entitled to know what is happening to the investigation. If a case has to be withdrawn, it can only be done after consulting the victim. And again, as sir said, a major bane of the criminal justice system that has been there all across the world is the delay that happens. As the dictum goes, justice delayed is justice denied. So, there is every need to have efforts to improve the speed of the justice delivery. And one of the cardinal features of our times is the ability to communicate electronically. So, that part is being integrated. So, there is provision for registering FIR electronically, there is provision for taking statements electronically. The trial to a great extent can be conducted through electronic means. So, the challenges that are out there in terms of the new crimes and the new modes of operations of crime, as well as the scope that is arising out of the latest technologies in improving the speed of the criminal justice system, that is also there in the new laws.
Okay. And as we speak, you know, there are two different sets of criminal laws here in the state, in the country, starting this July 1. Salim, I'm coming to you in this regard. You know, there's the existence of two laws now, the colonial era laws that have been applicable till July, but the cases registered till there and is being taken up even this month. Also, new cases being registered this month, and then you know it's undergoing a whole new set of laws. So, how is this coexistence happening, and the transition, particularly in the ground? Can you take us to the ground and you know give us a picture?
Yeah, you are right to the extent that you know there are two systems which are in coexistence. In the sense, the all criminal laws which was there before the 1st of July used to take care of the criminal justice system based on those IPC, CRPC and the Indian Evidence Act. All cases which were registered prior to 30th of June, day of midnight, those cases will still be continued to be investigated under the all criminal law. And then if it goes to the court and then the trial stage and then the proceedings in the court, everything will be done as per the all criminal law. So, there is no ambiguity in that sense.
Okay.
As far as the new criminal law is concerned, any offense, any crime reported, any information that comes to the police, particularly in terms of cognizable offense, now every crime, the registration is being done under the BNS, which is the IPC. So, all crimes in the state, as on date, investigation or the case registration has been done in terms of the BNS. Our police officers down to the level of you know ASIs, IOs who are the cutting edge and who actually carry out the bulk of investigation. They have been trained, they have been you know properly reskilled.
Okay.
And then there are so many technological apps, you know, there's so many guidelines and apps which actually makes the transition pretty easy.
Okay.
So, we have been, the department has been using all this through NCRB, through, you know, the BPRND and through MHA. We have been getting a lot of support in terms of, you know, the transition. And nowadays with the click of a mouse, we can just, you know, see which was the previous law and then the new laws which needs to be applied. So, the transition has been, at least in terms of police department, I can say very confidently that the police officers and all the district police are in cinch, and then they are able to, you know, without much hitches, able to transform, because largely the procedures remains the same.
Okay.
Though there are certain additions in terms of electronic videography and you know in terms of forensic and other technological you know requirements, the core of the criminal justice system still remains the same.
Okay.
Just as the sections have changed and certain procedures have been applied. So the transition is not so mind-boggling as it is made out to be. And then because you know the the central government as well as the state government as well as the state police has been working towards this transition from at least the last 6 months.
Okay.
So
okay.
we have been able to, I think, transform to the new laws quite smoothly.
So from what I'm understanding is that although the new 3 laws have come into existence now, the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita and the Bharatiya Sakshya Adhiniyan has come into existence, the core law still remains the same as in the laws that was already there in existence. I'm coming to you, Dr. Elias, in this regard. What really has changed? And if you could point out, some provisions, some involvement of new crimes that have been identified as crimes that was not considered a crime earlier. If you could point some of those as well.
Yes. As we discussed earlier, the main thrust of the change, we can say that the new crimes have been incorporated. And the new modes of operations of those crimes have been incorporated. And a more victim-centric approach has been brought in. And third, there is a concerted effort to reduce the delay in the operation of the criminal justice system. So, if we look at the first, that is to say the new crimes that are out there, we can see that as time passes, the criminal networks are getting very, very strong. We say there is a general process, what we call globalization. This globalization applies to crime also. So, crime is happening across the borders with much ease, with much more ease, I would say, using the electronic medium, using the advances in the transportation system. So, to address those challenges, organized crime of a grave nature and again organized crime of a petty nature, both have been incorporated.
Okay.
That is one a major change that we can see. And then, as I mentioned earlier, the right of the victims to know what's happening, right from the beginning, from the registration of the FIR till the time the case is charge sheeted, the victim has a right to know what's happening. And if at all there is a case that is going to be withdrawn, it has to be in consultation with the victim. Then, as I mentioned, the adoption of the electronic means of evidence collection, of taking statements, of conducting the trial are all expected to increase the speed of the criminal justice. And other things like those sad aspects of criminal justice system where under trial prisoner even going by the norms of the criminal justice system that we follow, he is innocent until proven guilty. So, there are a large number of people who are under trial prisoners. Now, there are provisions which gives more rights to those people who are under trial. If they have completed 1/3 of the sentence that they are expecting or they can be given, they have certain conditions being applied, they will be able to go home if the trial is still not yet begun. So, these are some of the larger aspects of the change.
Okay.
When we come to individual laws, we can discuss one by one.
Okay. Okay. On that note, I think we would come to individual laws. Also, if, as we speak, if you could also tell our viewers, the context of how this changes impacts the police force in implementing this. So, if we could start with the Bharatiya Nyaya Sakshya, Sarlima, you could take us.
Thank you. As Elias has already mentioned, see, the core of the criminal justice system has not changed. In the sense, the basic principle which governs the criminal justice system, we still have the adversarial system of criminal justice. And secondly, like he has rightly mentioned, the burden of proof, which is very important in any criminal justice system, is still innocent proven until guilty. That means guilty beyond any reasonable doubt. So, the core principle still remains the same. But certain procedural and substantive changes in order to reflect the changing times have been brought in.
Okay.
Now, for example, in PNS, as already highlighted on the issue by Mr. Elias, see now crime against women and children. This has been given a huge focus because there's a social outcry and social unrest all over the country. Nirbhaya case and all those we are still fresh in our memories. So, a very specific section and then more stringent section has been brought in crime against women and children. Then organized crime, like the syndicate crimes, which are happening, and then which has cross-border, ramifications, not just in our state, in northeast, beyond, and then across the border. So all this organized crime has been defined. It has been made more stringent. So this is organized crime was not defined in the previous laws. So this has been brought in. Another aspect is mob lynching. Mob lynching is a hate crime. Now, mob lynching was not defined in the previous IPC, but
Okay.
mob lynching finds a mention in the new criminal justice system under the PNS. Then aspects regarding community services. This is a very interesting development.
Okay.
Community services as a form of punishment. Okay. So earlier, like the concept of community service was not there. Now, for petty offences, for example, a theft. Okay, a person say goes and steals say a bread of loaf, or say an object worth of 100 rupees.
Okay.
In the previous law, it used to be the punishment used to be for 2 years,
Oh,
up to 2 years.
okay.
Now that has been done away with, and especially if he's a first-time offender, any amount which is less than 5,000. Okay, I'm just giving you certain specific. That will entail community service. So community service will be maybe he'll have to, clean the public toilet, or he may have to carry out some social work.
And who defines that
That
service?
the court will define.
The court.
The court will define. So, but that is the aspect in which we are trying to. That also helps in minimizing the declogging the prisons,
Okay.
because everybody, now what happens is in the previous law we used to just catch, even if he has got a small petty thing, they're sent for judicial custody. Now community services or drunken behavior, for example. Another aspect is drunken behavior. That also community service comes in. So all these are changes which are being contemplated, and snatching also as a part of theft, that also has been brought in. Mercy petition, then commission and revision of sentences. So there's a sweeping change which has been forcing in BSA, and and for a law-abiding citizen, it's absolutely secure. In fact, I think the entire intention of the criminal justice system is to ensure that lawbreakers are punished and the society is made more secure. So BSA actually, in terms of the substantive aspect, in terms of definition of crime, takes into account the new crimes which are happening and which poses very serious threat to the national security, to the well-being of society. So all these have been inculcated in the BSA.
Okay. Okay.
Yeah.
I want to pose the same question to you, Dr. Elias.
Yes, a few more points, not as important as what Lima sir has covered, because most of the most important aspects have been covered by him. One is that the negligent act which results in the death of a person carries a much bigger punishment now. Earlier, one of the confusions that we had was, unless the person have the intention to do that particular crime, what is called mens rea, whether it is there or not was a major concern. But if somebody is using his vehicle so carelessly, so rashly, that the death of a person happens, and which is something which have become very common in the last 10 years, so to say. So now that carries a punishment of 10 years,
Okay.
which I would say is a very welcome development. And some of the confusions that existed earlier, for example, there were a lot of sexual assault cases, sexual intercourse after giving some kind of offers that I will marry you. All those things, whether it was amounting to rape or not, created a lot of confusion. Now that has been defined as a new offense.
Okay.
So that clears a lot of confusion. Then again, welcome changes, as sir said, whole new chapter on crime against women and children have been incorporated. And one of the crimes defined is there, the hiring children to do an offense. For example, many a time when a child is caught, child means a 16-year-old boy, let us take an example, is caught with some drugs. Many a time officers used to think that this is an offense per se, but most of the time what happens is that an adult is using them to carry that. So that now is defined as a offense in the Major Act itself and carries a heavy punishment.
Okay.
And there are changes in punishments in very many sections. There are improvements in defining the minimum punishment, because one of the neglected aspects of criminal justice system is that to convict a person is, I would say, one of the major part of the decision making.
Mhm.
But what should be the quantum of punishment is a very, very major issue.
Mhm.
Unless it is titrated properly,
Mm.
a person who have committed the offense of culpable homicide,
Hmm.
that is to say, killing not amounting to murder,
Hmm.
he could have been let off with only a fine in the earlier section. Now it is not possible. The
Okay.
punishment has to be there, along with the fine has to be there.
Hmm.
Like that, more refined approach has been taken, I would say.
Okay, so a better concept of how to deal with different types of crimes
Yes.
in the new law.
And one last thing I want to add
Yes,
is BNS also have some definitions which are
Hmm.
very important. For example, earlier movable property only included corporeal things.
Mhm.
That is to say, only things which can be moved.
Okay.
But now it also includes non-corporeal, which means that the intellectual property rights, the copyright,
Mm.
trademark, all those things are also included in the movable property.
Hmm.
So
Okay.
that's that will have a major consequence,
Hmm.
even if it's a small change in the definition.
When we talk about the BNSS, if you could also highlight some of the changes most relevant to the police, because I think this is a code mostly the police and the law,
Yeah.
the courts has to deal with. So, Dr. Ilyas, I'm coming to you first in this regard.
Yes, the whole set of changes are there. If we look at the thrust, one is to incorporate more forensic inputs into the investigation.
Hmm.
The other is, as I mentioned earlier, to bring in the advantage of electronic media
Hmm.
in the case of registration, in the case of taking statement, in the case of conducting trials. And then, of course, efforts to speed up the trial.
Hmm.
So now coming to the different stages, a case being registered.
Hmm.
Now there is a provision for a preliminary inquiry in certain set of offences, which was not there earlier.
Without a case being registered in this case? or-
Yes,
Okay.
but there is a time period defined. It has to be
14
inquired
days.
into and decided whether we are going to register an FIR or not within
Okay.
that time period.
Hmm.
And after registering, coming to the arrest.
Hmm.
Arrest now a person who is above 60
Hmm.
or suffering from some infirmity, and the offence is rather light, carrying a punishment of less than 3 years of imprisonment. He cannot be arrested unless the DSP rank officer gives a permission.
Hmm.
So that gives, what should I say, more importance to the human rights of people,
Mhm.
we can say. And now again, there is a provision for private arrest.
Hmm.
Even a private person can make an arrest. That was there in the earlier act, that is there in the new act also. But now the new act defines the time within which he has to be handed over to police.
Okay.
He cannot be indefinitely kept, and it's
Mhm.
only a matter of few hours which is given to that.
Mhm.
So in a way, it clears a very important aspect of, which I would say is very relevant in the case of Nagaland.
Okay.
Then coming to the investigation, we have to use the forensic inputs mandatorily if the offence is of a grave nature. Then again, when summoning the summoning the person, the electronic means can be used.
Hmm.
That is to say, if a WhatsApp message
Hmm.
so defined with the conditions applied,
Mhm.
that also can serve as a summon. Earlier it has to be a paper, it has to be
Mhm.
given to the person. All those things have been reduced. And again, the CRPC deals with how the trial is conducted.
Mhm.
So the provision for conducting the trial through electronic media,
Hmm.
all those things are there.
And as we talk about this, there are also arguments that the new criminal laws, they empower the police too much, that it could be a state of police, or that the police could abuse power. Sarlima, if you could, give a clarification or your statement. on
Yeah,
that.
I mean, that I think is a misconception. In the
Okay.
sense, see, the power of police, when we talk of police being empowered under the CRPC, it has to be seen in terms of the checks and balances that are already there.
Hmm.
In fact, the use of electronic medium,
Hmm.
the use of electronic video, medium,
Hmm.
digital medium, electronic digital medium. The basic idea is to infuse transparency
Hmm.
and to bring accountability in the criminal justice system.
Hmm.
For example, now when the police is supposed to conduct a search,
Hmm.
and search is a big power that police has.
Right.
Now when we conduct search, now in the search procedure, now mandatorily the IO has to record the search procedure.
Visual
Yeah,
record.
visual recording,
Okay.
even with a mobile phone.
Okay. Okay.
Okay, so the chances of, we call it padding of evidence,
Hmm.
or falsely putting evidence.
Right.
All these are minimized.
Hmm.
Then everything has to be video recorded, including the search procedures, the signature which has been done by the independent witnesses.
Mm-hmm.
All these are recorded now.
Hmm.
So search procedures have become more transparent.
Hmm.
That is one aspect. Secondly, as already mentioned, in terms of arrest, you know, again, arrest now mandatorily, one ASI has to be designated in every police station,
Hmm.
who will be the single point of contact for all kinds of information pertaining to any arrest.
Okay.
Okay, and there has been a lot of curb in terms of arrest,
Hmm.
because now, as rightly mentioned, infirm 60-year-old
Hmm.
or a child below the age of 15, you know, all this, like if the offences are petty in nature,
Hmm.
less than 3 years, now police cannot arrest, and
Hmm.
IO cannot arrest until and unless a superior officer in the rank of DSP actually gives the permission. So all these checks and balances are very much there
Hmm.
within the system, and you know, in terms of perhaps in terms of investigation,
Hmm.
in terms of attachment of properties, in terms of you know, proclamation offender, all this because a person is absconding
Hmm.
who has committed crime.
Hmm.
Okay, and then what happens is he sometimes he goes out of the country.
Hmm.
I mean, especially, you know, in other parts of the country. Now the law has empowered in absentia trials.
Hmm.
In absentia trials within a period of 90 days from the day the charge sheet has been filed.
Okay.
Okay, so in absentia trial means even if he's not there in person,
Hmm.
if there are any enough evidences, the person can be actually prosecuted,
Okay.
and that helps in extradition and other things also.
Mm-hmm.
So those are aspects which have been looked into. So and then one important aspect for the police, perhaps in terms of investigation,
Hmm.
is judicial remand, police remand.
Mm-hmm.
Police remand generally, you know, it's for 15 days, and we could take it at only one stretch.
Hmm.
Now we can take it in parts,
Hmm.
and because, you know, in the process of investigation we may discover certain facts
Okay.
which needs corroboration from the accused.
Mm-hmm.
Then we can always reclaim him or recall him back
Hmm.
within a specified period. So you know, there are always checks and balances,
Hmm.
and yes, we cannot completely rule out the power of abuse or
Hmm.
the chances of abuse, but at the same time, you know, because of the transparency that is being brought in, and now, for example, FIRs,
Hmm.
EFIRs are mandatorily to be recorded by the police station.
Okay.
EFIRs, and it has to be signed within 3 days. Now, zero FIRs. Earlier, I think one of the major problems that we faced all over the country was that, you know, I don't have jurisdiction.
Hmm.
You know, you go to a different police station.
Right.
Now that excuse is not there with the police.
Mm-hmm.
Zero FIRs has to be compulsorily filed, so jurisdictional issues are not there anymore.
Mm-hmm.
So the system is aware. The criminal justice system is aware of the abuses that can happen within the police framework, and then it is sought to be, I think, mitigated by bringing in more transparency, by bringing in, and then forensic, for example.
Mm-hmm.
Now, if forensic examination comes, then the chances of, you know, mishandling the investigation also minimizes.
Mm-hmm.
So all these checks and balances are there,
Mm-hmm.
and that's how I think police cannot be said to be, you know, I mean, whatever has been empowered, whatever power has been given has been with subsequent checks and balances within the law.
Mm-hmm. Since we're running short of time, I'm quickly coming to you, Dr. Elise. If you could tell us, you know, the importance of having evidences and the importance of the BSA.
Yeah, Bharatiya Sakshi Adhinayam, what was earlier Indian Evidence Act, deals with evidences. The major change, I would say, has been incorporating the electronic evidence as evidence and also as primary evidence.
Mm-hmm.
Earlier, the document included, after some amendments, conditionally electronic evidence also, but now it is clearly incorporated as a proper part of the law.
Mm-hmm.
And the modalities of presenting those digital evidence also have been clearly enunciated. And secondly, the electronic modes of giving evidence also is incorporated. So these are the major changes, but there are some smaller changes. For example, the co-accomplice, his testimony can be taken against the other accused, provided his statements can be corroborated and certain other conditions. And something like earlier the court-martial proceedings, the Indian Evidence Act did not apply, but the Bharatiya Sakshi Adhinayam will apply to that also.
Okay.
Then there are, generally we can say that the range of primary evidence has increased. The range of secondary evidence also has increased. For example, there is a concept called res geste.
If you could repeat.
Res geste.
Okay.
GSTE. That is to say, somebody says fire, after a fire is erupted. So that statement gives some sort of clarity when it comes to we are going back to the statements. So this could be accepted only in what is called relevant facts, in facts and evidence only. Now it is applicable to the relevant facts also. So generally we can say that more set of evidence can be accepted with proper corroboration and other steps ensured to convince that this is actually a proper evidence.
Okay.
That is where perhaps if I can add,
Yes, please.
the importance of actually, attaching standards to the electronic evidences in terms of storage, custody, because electronic medium can always be manipulated. So the storage, as well as the custody, then the transmission and broadcast, all the standards have to be met, and that is where Evidence Act takes care that to ensure that the standards of evidence, the standard of proof is met. So all these inbuilt systems are also there, as well as the admissibility, the legality, and the enforceability of the Evidence Act. All these standards have been taken care of in the new law.
Salim, also one very briefly, if you could highlight maybe some of the general challenges of implementing the 3 new laws.
By the police department.
Yes.
See, in the context of our state, infrastructure, and generally speaking all over the country, infrastructure is a big issue, because now for any offense above 7 years of punishment, we require forensic teams to mandatorily visit. So our forensic capabilities really has to be augmented, and district police and other, the formations, all these districts also will have to be given the due forensic backups. And then when we talk of the electronic video digital means, then the IOs, the police officers, down to right from the rank of DGP down to the IOs, we need to really upgrade the capabilities of electronic and digital devices, including videography, mobile phones, and then we need to have standalone, in the sense that it should be purely for the professional work. You can't use your own mobile phone and then tomorrow if it gets corrupted, the evidence gets destroyed. So we also require a lot of upgradation in terms of the electronic equipments and the digital requirements. And also the process of training is a continuous exercise. So that has been undertaken at the respective level, even by the SPs and also at the level of police headquarters. So these are the challenges that we foresee, and it is a continuous process wherein we would require the support of the state government as well as the central government in order to make the transition smoothly.
Okay. With a wealth of knowledge, you both have so much to share, but we're running short on time, so the conversation will end here for this episode. But I request to our viewers to join us for the next episode, because we will continue a conversation on the new criminal laws. Joining me on this episode, we had Mr. Lim Asanab Jamir, IPS, IGP Range Nagaland, and Dr. KPA Ilyas, IPS, DIG, CIT. I hope this episode was as informative for you as it was for me, and I hope you stay tuned with Doordarshan Kendra for the next episode on the new criminal laws. Thanks for joining us. I'm Madeline Ambrosia, signing off from DDK Kohima.